Graham continued his primary school education at St Andrews Prep and moved on to St Andrews College, where he matriculated in 1991. Since his parents were old Rhodians, the young Graham Glover benefited from an old Rhodian bursary, which enabled him to take up a place in College House of Founders Hall and read for a BA degree starting in 1992. He remembers his warden, Sean Colin, as one of the greatest wardens in Rhodes University history. And I'm sure many of you more senior academics remember Sean Colin. Professor Glover completed his BA degree in 1994 with a double first in law and history and numerous laurels along the way. The Sandlam Prize for the Joint Top Student in Legal Theory 1, the Rhodes University and Dr. Kendall Scholarships for Academic Achievement, the Spilkin Prize for the Top Student in Legal Theory 2, and he was a rare undergraduate winner of the Milner Memorial Essay Prize for British History. In 1995, Graham moved on to an LLB degree, which he again completed with distinction and again earned numerous awards. The Pierce Ruud Scholarship, the Adams and Adams Prize for Commercial Law, the Fred Cooper Prize for Company Law, the Alistair Kerr Prize for the Law of Contract, the Professional Providence Society Prize for the top penultimate LLB student, the Butterworth's Prize for mooting, and both the Judge Schock Prize and the Juter Prize for the top student in the LLB final year. According to the registrar at the time, Dr. Keith Hunt, Professor Glover was the first Rhodes University student to earn academic honors in 2 different faculties. Although it seems evident that Professor Glover's priority as a student was his studies, he also strove for the balance that all students are encouraged to seek in preparing for a healthy life. He played hockey for Eastern Province Country Districts, and he represented the university's first tennis team for 10 years. During that time, he was both the chair of the tennis club and the captain of the team, notably for 2 Eastern Province Premier League titles. It turns out to have been the most successful tennis era of this university. And of course, being a Rhodes student, there had to be some liquid refreshment along the way. He chaired the university's Wine Cultural Society for a time. And just to show you that this was not down at the rat, he once achieved 4th place in the National InterVarsity Blind Wine Tasting Competition. Professor Glover took up a master's degree scholarship to read for an LLM here at Rhodes University again, which he ultimately converted to a doctoral degree, completing a thesis entitled The Doctrine of Duress in the Law of Contract and Unjustified Enrichment in South Africa. He graduated at the centenary ceremonies of 2004. By this time, he had already taken up a post as a lecturer in the law faculty, which he did in October 1998. And then he was promoted to senior lecturer in 2004 and later to associate professor in 2008. What we're celebrating this evening is his promotion to full professor in his 25th year of service to this university. Aside from a heavy undergraduate teaching load in the law faculty, Professor Glover has supervised to completion 2 PhD and 3 LLM students, has published 30 sole authored accredited journal articles, 3 books, 2 of them edited collections and 1 a monograph, and 8 book chapters. His various works have been cited 38 times in the High Court in South Africa, including 9 times, 9 citations by the Supreme Court of Appeals. Professor Glover is married to Margot, to whom he leaves the practice of law while he focuses on the academic side of the law. And he's often to be seen walking their 2 dogs in the evenings. I think they probably lost out this evening. So it is my great pleasure to invite Professor Graham Glover to deliver his inaugural address.
Deputy Vice Chancellors, Deans, colleagues, and guests. To hold a chair in law at Rhodes, only the 17th person to do so in 117 years since law was first offered here in 1905, is one of the great privileges of my life. The granular origins of the journey were in fact in this town. My parents, my father Brian from the border town of Mutare in Zimbabwe, and my mother Colette from Windhoek in Namibia, met each other as students at a Founders versus St. Mary's Hall cricket match on King Field in 1967. As is often the case at Rhodes, the cricket was undoubtedly just an excuse for the social event that followed. Their time and experiences at Rhodes were special enough to motivate them to name me Graham, after the town in which they had studied and met when I arrived on Valentine's Day in 1974. The first 10 years of my life were spent in Zimbabwe, where my parents were school teachers. And my sister Jane and I grew up in quite idyllic circumstances on the local school grounds in the small town of Marandera, mostly oblivious to the horrible war going on in the country, but which would thankfully be over by the time we commenced school. Apparently, my mother considered it quite important that I be clearly identifiable at all times. Anyhow, since my birth, I have lived my entire life surrounded by education, and I literally cannot imagine a life outside of it. In late 1983, as you have heard, my father was offered a position as head of the geography department across DSG and St. Andrews, and the family moved to Grahamstown. My parents unselfishly took this step, specifically with a view not to their own interests, but to my and my sister's educational interests. Starting afresh in a new country, aged in your late 30s with 2 young children, is no easy thing. Both my parents made huge sacrifices to allow me to have the benefit of a private school education and then to come to Rhodes. The hardest thing about tonight is that neither of them are alive to see this culmination of everything they set in motion when I was small, and insisted that whichever one of them looked most alert read to me before bed. I can only hope that they are up there somewhere watching and are proud of where I have ended up, even if the last thing they might have imagined on King Field 55 years ago was that their son might hold a position held then by the forbidding Professor Robin McCarran when they were students. At least I can deeply appreciate the virtual presence of my sister extraordinaire, Jane, my brother-in-law, Scott, and my nephew, Charlie, from the UK. I have no doubt that Charlie has already asked why his uncle is wearing this strange costume. Jane is, of course, a doctoral graduate of Rhodes herself, one of the brand of scholar who in the 2000s broke from the then English department's canonic tradition to research works of popular fiction, including her MA thesis on the first 4 books of the Harry Potter series. If she had had her way, the title of this lecture tonight would have surely been Agency Law for Muggles. Although my blood family cannot be here in person tonight, I'm grateful to have my partner in life, Margot, here to be able to represent the broader Glover Beard clan. There we are outside the chapel on our wedding day, just by the law faculty. There's a saying that goes that behind every successful man, there is a very surprised woman. But in my case, that would not be true. Whereas I am often inclined to doubt myself, I am constantly fortified by having a daily presence in my life who has no such doubts about me. That support and encouragement makes a huge difference to me. as well as your acceptance of how you have to share me with my marking, my writing, the South African Law Journal, and of course the dogs. I also wish to acknowledge tonight the support of my broader legal family, my colleagues past and present, from the faculty too numerous to mention, who have walked parts of, or in some cases the whole of, this path side by side with me. My time as a student at Rhodes was very special. I initially enrolled with a view to studying languages, particularly English, on the back of a strong performance in the National Schools English Olympiad. I took law in first year more for interest's sake, but I found in law a field that suited my left brain analytical bent. Things very nearly ended before they had even started, though. Professor Rob Midgley distributed a giant pack of reading material in our very first lecture and quipped that he would follow up this first week's reading with the next week's material the following Monday. I spent a few frantic days casting aside all the usual distractions of first term as a first year, plowing for hours with increasing anxiety through about 800 pages of largely incomprehensible material. I told my mother on the weekend that if this was what law was about, I definitely wasn't going to cope. To my great relief, when the next week came, I discovered that Professor Midgley had been pulling our leg, and this was in fact the reading material for the entire year. I'd just not seen the twinkle in the eye. Little was I to know that he would be the dean when I was appointed to the staff and would act as my doctoral supervisor. I was privileged to be lectured as an undergraduate by some great lecturers and characters who shaped me as a teacher-scholar. There was Brenda Bell and Ron Hall's passion for their subjects, so crucial to teaching success. Julian Cobbing and Brenda Nichols's insistence in their own very, very different ways to challenge myself and my subject in what became my other major, history. And Paul Malem, who became my model for how to structure and plan a lecture. And then there were, of course, my law lecturers, notably Ross Harker and Ivan Schaefer, who entrenched in me the need for deep reading and understanding of case law, with which I torture the next generation of students. And John Grogan, of course, as a model to try to emulate for how to write and communicate, to try to make the complex seem simple. It was when I began tutoring first-year students in my penultimate year that I realized the apple had not fallen far from the tree. The practice of law held no attraction for me. I had my parents' blood. What I wanted to do was to teach and write about law. So began a professional journey that commenced in 1998, thus allowing me the professorial privilege of saying to our wide-eyed students, I began lecturing last century. I've taught across a wide spectrum of legal areas, so often the fate of a young lecturer in a small faculty. And my research career has, perhaps unusually these days, tended to replicate this sweeping terrain. Unlike many current scholars who, driven by the dictates of NRF focus areas and ratings requirements, tend to focus their work in one very specific area, I have been a bit more of a magpie, indulging my curiosity across all sorts of fields and areas of interest. Oddly, my publication that has attracted the widest academic interest from an eclectic mix of legal academics, literature academics, and historians around the world was a legal historical analysis of Charles Dickens's litigation skirmish with the Eastern Province Herald for copyright infringement in the 1860s. That is obviously a far cry from the academic bailiwick into which my more mature career has settled. Broadly, research into the modern general principles of contract law and the specific contracts. This was the subject area of my doctoral thesis on duress in private law, motivated initially by a research assignment on the topic presented to the 1995 LLB Law of Contract class by our lecturer, Advocate Torkel Patterson, SC, who is with us tonight. That I settled in this area is not entirely surprising, considering this was the area of specialization of the faculty's greatest ever professor, in whose towering shade we all work, Professor Alistair Kerr. Had he lived on, Alistair would have been 100 years old this year. Although he was more of a Hartian than the Dworkenite I am, to have had him as an academic mentor of the most rigorous and punctilious kind was a unique privilege. Alistair wrote his doctoral thesis on the law of agency. It is in his honor that the academic portion of this lecture takes up this theme. Many South Africans are familiar with the story of Mr. Nkosana Makate's ongoing battle against the cell phone giant Vodacom, his former employer, for compensation for his please call me idea, which allowed a cell phone user with no airtime to send a please call me request to another person. Less well known is that his case has motivated some revisionist analysis of how we understand and explain representative agency from a legal perspective. At the legal heart of the case was whether Vodacom's Director of Product Development and Management, Mr. Philip Gessler, had the authority to bind Vodacom to a contract to compensate Mr. Makate if the please call me idea was successful. I shall return to this matter a number of times anon. The aim of the appointment of an agent is to provide representative assistance to a principal party. What the principal finds it impractical, inconvenient, or difficult to do, the principal decides to do through the assistance of an agent. The legal concept of agency is highly significant in a modern free market economy. In a world dominated by corporations and other forms of business structure, there is hardly a transaction which one concludes which is not settled with some sort of representative agent of the impersonal juristic entity with which one does business. Every employee operating a till at a supermarket, for example, Pick n Pay, acts as an agent for sale for the business that is Pick n Pay. Numerous actors at Rhodes, from the Vice Chancellor and Registrar down to departmental and hall secretaries, act on a daily basis on behalf of the entity that is Rhodes. Those calling themselves agents operate in many other contexts too. Real estate agents, for example, are regularly used by buyers, sellers, lessors, and lessees. Authors, performers, and athletes often retain specialized agents to represent their interests in dealing with third parties. Who can forget Tom Cruise's performance as the sports agent in the film Jerry Maguire, shouting, "Show me the money" to Cuba Gooding Jr.? Agency may be a ubiquitous commercial practice with a long history, but it has paradoxically been an area of law whose conceptual attributes have been the subject of debate, not only in South Africa, but in other jurisdictions too. In the South African context, part of the reason may be because, in common with much of modern South Africa's private law heritage, South Africa's agency law is a hodgepodge hybrid of a number of received colonial sources, a casuistic patchwork combination of the Roman Dutch law of mandate and the Anglo-American principles of commercial agency. The result is that there has been no clear uniformity of approach in South African law about the essential features and range of application of agency. The leading authors have seldom found common ground, and commentators have admitted that the position in South Africa is by no means completely theorized. This lecture seeks to propose some answers to this deficiency. So, what then is the essential juridical nature of agency? Jurists in the 20th century tended to postulate one of two competing explanations: the consent theory and the power liability theory. The consent theory has traditionally been the dominant force in Anglo-American jurisdictions, to the extent that it has commonly been suggested that agency is a type of contract. For example, Lord Pearson said in 1968 in the House of Lords decision in the Garnack Grain case, the relationship of principal and agent can only be established by the consent of the principal and the agent. Lord Brown Wilkinson reiterated this point of view in 1993 in Kelly versus Cooper. The resolution of this case, he said, depends on two fundamental propositions. First, agency is a contract made between principal and agent. Second, like every other contract, the rights and duties of principal and agent are dependent on the agreed terms of the contract between them. The consent theory of agency is attractive due to the fact that it embraces the relational nature of agency. It also reflects the actual consent basis of liability between principal and agent in many cases, and that most of the legal obligations attendant upon agency have a contractual feel about them. It provides the potential for a wider approach to agency, which is not necessarily limited to requiring that the agent be entitled to bind the principal when engaging with third parties. However, the theory has attracted criticism since it focuses specifically on the internal relationship between principal and agent and pays little attention to how the agent engages with the third party. While there is nothing wrong with saying that agency arises out of a voluntary relationship, to distinguish it from cases where authority arises in some official way, for example, by order of court, the idea that a consent theory automatically equates to a far narrower idea of a contract of agency is problematic. This is because, as we shall see, there are numerous situations where the law will accept there is agency, but where there is no possibility of this conclusion deriving from consent as we normally understand it in contract law. So, the critics of the consent theory offered up in its place the power liability theory. This theory has tended to dominate European civilian analysis. The approach draws a clear distinction between the practical interaction between agents and third parties and any underlying legal relationship behind that. The theory focuses its attention specifically on the former issue, the actions of the agent and their consequences for principal and third party. This theory was the one preferred by the great American rights theorist, Yale's Wesley Newcomb Hofeld. Hofeld claimed that agency is characterized by power-conferring legal rules. The principal confers power on the agent to act. The agent then has the power to conduct business on behalf of the principal. The agent is under a correlative liability to act in accordance with the powers he was given, and the principal is under a liability to honor any transactions entered into by the agent. According to this approach, the question of the relationship between principal and agent is not too important to the inquiry. The power liability theory has its attractions, but it too has limitations. In contrast to the consent theory, which has an internal focus, the power liability theory concentrates almost entirely on the agent's external actions with the third party, barely considering that the majority of agency relationships are grounded in some relational basis. This theory also hypothesizes a narrow form of agency, since any acts that do not result in the principal's legal relations being contractually altered by the agent's exercise of power cannot fall under the definition of agency. South African sources neatly reflect the broader international debate between these two theories. Not unusually, South African courts have not spilt a great deal of ink on theoretical concerns. Some decisions adopt a consent approach and refer to a contract of agency. Other decisions, by contrast, focus on power and liability as central concerns. Not surprisingly, therefore, the debate about the appropriate theoretical framework to undergird agency law in South Africa has played out most prominently then in the approaches of the main writers on South African agency law, all of whom wrote in the 20th century. A group of authorities adopts a consent model, going as far as to position the concept within a framework of a contract of agency. The source most explicitly associated with this approach is the most detailed 20th century monograph on the subject in South African law, De Villiers and McIntosh's The Law of Agency in South Africa, although Alistair Kerr adopted this approach too. By contrast, other South African authorities, mostly from the historically Afrikaans universities, abjure dismissively the consent model in favor of a power liability model. The father figure of this approach in South Africa was Stellenbosch's enormously influential Professor J.C. de Wet. So, bearing in mind the desirability of theory reflecting doctrine, in the spirit of the Hegelian dialectic, there is now an increasing acceptance that agency is such a multifaceted phenomenon that neither of the consent nor the power liability theories can adequately explain the totality of agency law on their own. The power liability model is ontological. It emphasizes a descriptive jurisprudence, focusing on the mechanics of how agents tend to work in practical terms. By contrast, the consent model is normative. It focuses on why the parties come together in a form of relationship we call agency in the first place, and the duties this then entails for the parties. Neither is the right or wrong way to explain agency. The two theories merely emphasize different but important aspects. One tends to focus on the external aspect, the other the internal aspect. In fact, these two models each illuminate different facets of a complex structure that is agency. Both of the world's two most influential recent agency works, the last two editions of Boustead and Reynolds on agency in England and the American Third Restatement on agency, now explicitly recognize this reality. These works prefer to describe agency by means of a synthesis approach, which incorporates a modified engagement with both forms of theoretical analysis, and which sets out to cover as much of the complex structure of agency as is possible. In this lecture, I thus motivate for the adoption of a synthesized approach to describe the features of agency doctrine in South Africa in a thoroughgoing manner. So, if we accept that agency is a complex and protean phenomenon, it is thus unsuitable to attempt some sort of thin definition of agency, as if it were a term of art. It is instead preferable rather to identify various defining characteristics of agency, with a view to extrapolating from these, all with the purpose of constructing as complete a taxonomic picture as is possible of agency law. What are these characteristics? Well, I've numbered them for us. First, in its most complete sense, agency encompasses both an internal and an external aspect and has both inward and outward-looking consequences. The internal aspect focuses on the relationship between principal and agent, how it arises, and the rights and duties that flow from it. The external aspect focuses on the agent's ability to engage with third parties. Secondly, for analytical purposes, the internal aspect should be the primary starting point. The creation of a relationship is naturally antecedent to and the justification for the exercise of any actions by the agent. This is because agency is at its heart a type of voluntary relationship. Thirdly, the internal agency relationship between principal and agent is one that is fiduciary in nature. The fiduciary concept is not susceptible to easy definition, but its hallmark is that by virtue of a relationship, one party is placed in a position of trust vis-a-vis another party, and therefore has an obligation to act first and foremost in the best interests of the principal party himself. The fiduciary duties of the agent are classically said to be to do what they've been asked to do, to exercise skill, care, and diligence, to impart information, to advise, to act in good faith, and to account. The principal, in turn, has obligations to pay the agreed commission or remuneration, if any, to account, and in certain circumstances, to indemnify the agent his costs. Fourthly, the agency relationship is established by a principal allowing an agent authority to act. The concept of authority, or the process of authorization of agent by principal, is therefore crucial to understanding agency. So how then do we identify when a principal has authorized an agent to act? It is here that the 20th century consent model that used to dominate the understanding of the internal relationship of principal and agent has undergone important 21st century modification. Rather than seeing consent as the basis for authority, which, as we have seen, some South African authorities cling to, it is now becoming the norm internationally to view the test more broadly and to say that it is the principal's manifestation of assent to act that confers authority upon the agent. Two important adjustments are apparent here: the reference to manifestation and the use of the word assent. What is meant by a manifestation of assent? The American Restatement defines manifestation as indicated. A manifestation is conduct by a person, observable by others, that expresses meaning. It is a broader concept than communication. The relevant state of mind is that of the person who observes or otherwise learns of the manifestation. Conduct is therefore the driving feature of manifesting authority. The conduct could occur by written directive, spoken words, or by any other conduct indicative of authorization. That is why it is generally said that authority was granted or conferred upon the agent by the principal, or that the law recognizes that this has happened. As the definition goes on to indicate, the nature of the inquiry is an objective one. It's determined by observation of the principal's conduct and how that would be received or understood. This is also why I use the portmanteau word assent, because the circumstances in which a principal may be said to make such a manifestation are far wider than communicated consent in its traditional subjective form. The view is reinforced by the fact that, as we are about to see, there are a number of circumstances where agency authority is said to be conferred, but where there is no bilateral process of offer and acceptance between principal and agent at all. So, how then does one identify that a principal manifests assent? First, we must take a step back and understand why the consent theory has traditionally been so popular. That is because the most common way in which authority is manifested is by a process of granting actual authority to the agent in some underlying agreement. In other words, actual authority is often established in terms of some express background contract. If the principal and agent do actually choose to establish their relationship and create authority by contract, what sorts of contracts would these be? Well, the first would be a contract of mandate involving agency authority. So, for example, a once-off appointment of a person to go to renew your car license because the horror of going yourself to the Makana Traffic Department is just too much to bear, if it is even open. The second possibility would be a contract of employment, which contains some sort of ongoing agency authority. So, for example, the sales employees at Pick n Pay, who are empowered to sell you your groceries or take your money, are empowered classically by their employment contract. Thirdly, some contracts containing an authority may more properly be classified as the contract of the independent contractor. And I shall discuss the position of these arrangements, for example, those involving estate agents, in due course. It is these forms of actual authority which traditionally inspired the idea of a consent theory of agency. But as I've already hinted at numerous times, we have long recognized in practice that there are other ways in which agency authority manifests which have nothing to do with the principal or agent actually entering into a consensual agreement containing some authority. The first example is the granting of powers of attorney, another common method of manifesting authority. The declaration contained in a power of attorney is the classic example of a unilateral juristic act, in that its very completion constitutes a manifestation of authority in writing, and no acceptance is necessary to constitute the authority or empower the agent. So, for example, when my father chose to immigrate to Australia in 2001, he gruffly came home one day, preferred me a document and said, "This is my power of attorney that you act on my behalf relating to any issues concerning me once I've left South Africa." It had been done with Richard Lang at Wealden's 4 days before. The mere fact of his completing and signing it with Richard vested authority in me. I could have renounced it, of course, I didn't. But the fact was that my authority existed as a legal fact 4 days before I had a clue about it, and I had certainly never consented to it beforehand. Secondly, there are some circumstances where actual authority may arise purely by operation of law, as the result of the principal and agent being in some sort of designated commercial relationship. For example, the board of directors of a company automatically has authority to perform agency functions on behalf of the company in terms of the Companies Act. No consensual agreement is necessary. Thirdly, a manifestation of authority may also be said to exist even in circumstances where there is no actual grant or conferral of authority made to the agent at all. How so? First, it is possible for a principal ex post facto to ratify an act of someone who transacted with a third party, allegedly on behalf of the principal, despite knowing he had no authority to do so at the time whatsoever. Ratification operates as a legal fiction. It pretends as if there had been authority when the agent acted, when in truth there was none whatsoever. The principal in the new terminology, however, by ratifying, assents to what had happened, although there was never any consent in the first place. Next, and most significantly, the principal may manifest the existence of authority to a third party, not the agent, leading a third party legitimately to believe that a principal had given authority to the agent, even if in truth that was never the principal's intention. For example, an employee of a bank may be given a title, let's say Manager Investment Division, and that manager may be allowed to act by the bank to suggest to an outsider that this employee manager is authorized to give financial investment advice to clients. In fact, no such authority may actually have been given to the manager at all. Perhaps the person is simply employed to manage that section of the bank bureaucratically. Or perhaps a very limited form of actual authority was given in the employment contract. Perhaps that the manager may only invest the bank's money, but may not assist clients with advice. But such limits, internal limits, were never enforced, nor are they apparent to a third party in their interactions with this manager. Such authority is known as apparent authority, or sometimes ostensible authority. While this might initially appear to be no true authority at all, this again reflects a pure consensus view of agency. As Lord Denning famously said in the case of Healy-Hutchison versus Braehead, apparent authority is authority as it appears to others. So apparent authority derives from a third party's objective view of the apparent relationship between principal and agent, or what the principal apparently and objectively represented about the agent to the outside world, whatever the principal's real intentions. It's here we return to the Makate case. Mr. Gessler, in fact, had no actual authority to contract with Mr. Makate on behalf of Vodacom. His actual authority as director of project development and management in his employment contract was quite limited. But the CEO of Vodacom and its board had allowed Mr. Gessler such free rein, frequently condoning acts outside of his job description, that to a third party such as Mr. Makate, it appeared objectively that Mr. Gessler apparently did have authority to conclude contracts on behalf of Vodacom, or that Vodacom had manifested its assent that Gessler could act as agent. Hence, ultimately, the Constitutional Court's finding that Vodacom was indeed contractually liable to Mr. Makate. Historically, the doctrine of estoppel has been used to identify cases of apparent authority to the extent that it was understood that apparent authority and estoppel were the same thing. However, in the Makate decision, a majority of the Constitutional Court held, controversially, that apparent authority and estoppel are different things. So, for present company, the good thing is that I therefore do not need to bewilder you with what estoppel is, since the concept tends to send shivers down even the most experienced practical lawyer's spine. The difference and the implications of this significant decision are something which one of my research students, Tembelani Ncube, sitting up there, and I are currently engaged in working as an ongoing research project. So, the fact that authority may be manifested objectively in a variety of ways and need not be manifested to an agent at all, but also to a third party, or may be found to exist by unilateral power of attorney, process of statute law, or by ratification ex post facto, re-emphasizes a crucial point. With apologies to Professor Kerr, while agency involves the establishment of some sort of legal relationship between principal and agent, this is not the same as saying, as the consent theory used to put it, that agency is a contract. The internal relationship may often exhibit contract-like features, especially in cases involving actual authority established by mandate or employment. But as we have seen, a manifestation of authority can occur and an agency-authority relationship can arise in a whole host of other ways too, which are not contractual in nature. And Barstead and Reynolds summarizes this very, very nicely. They say, the basic justification for an agent's authority is the idea of a unilateral manifestation by the principle of the assent that the agent is authorized to act. To this, any contract between principal and agent is secondary, although there will sometimes be one. An underlying contract is unnecessary to the manifestation of authority, which may occur in other ways. So much for authority. Authority requires explanation or justification, the exercise I've just carried out. Once it can be concluded that the agent has authority as a matter of fact, in the paradigm case of agency, that authority forms the basis of the power the agent has to affect the principal's affairs. Authority and power are hence not the same thing. Power is a neutral concept which describes the result or the consequence of there being authority. It focuses on the external aspect of agency and the outward consequences that arise when authority exists. For example, the agent may have the power to convey the principal's property, the power to conclude a contract for the principal, or the power to discharge a debt owed by the principal. Once an agent is invested with such powers, the principal has that legal liability to accept what follows, whether it's beneficial or imposes burdens on the principal. And then, in terms of the paradigm case of agency, once an agent is clothed with authority and is thereby empowered to affect a principal's legal relations, the agent may then proceed to represent the principal by transacting with third parties on behalf of the principal. Representation is therefore the external performance aspect of the agency relationship, the overt act of the agent exercising their authorized power for the principal. In the Makate case, the representative act was that of Mr. Gessler, concluding a contract one-on-one with Mr. Makate for compensation. But the duties arising from that act attached to the principal, Vodacom itself. What I've traversed above in the first 6 features concerns what I have called the paradigm case of agency already, which has also been described as empowered agency, including both internal and external features. Now, the bulk of authorities in South Africa adopt a very narrow approach to agency and consider this to be the sole and exclusive province of agency. De Villiers and McIntosh, as I indicate here, are very firm on the point. They say, a specific characteristic of agency in the legal sense is the authority conferred on the agent to make binding contracts on the behalf of his principal. To describe as an agent persons who do not possess this distinguishing characteristic, such as, for example, the estate or house agent, is for legal purposes inexact. A person who has authority to act for another cannot be regarded in law as an agent unless that authority covers the creation of contractual obligations between his principal and third party. The quotation raises one of the main examples of a party falling outside this traditional narrow definition of agency, the estate agent, who normally sources and introduces prospective purchasers to a seller and may act as an intermediary communicator of information, but who has no power to conclude any agreement for the principal. Others include travel agents or insurance brokers. In the case of Mackenzie versus Flight, Mason J., adopting this narrow approach, described the use of the terminology of agent in these circumstances as merely convenient, and that although they may bear many of the characteristics of agency and involve many of its obligations, they are in truth arrangements for a special service of a different kind. So, something you may not have known before tonight. An estate agent is not an agent. Well, ought South African law to adopt such a restrictive approach to agency and the concept of representation? It's certainly true that such parties, though sometimes called introducing or canvassing agents, do not meet the narrow internal and external characteristics set out in the paradigm case of agency. It might then be analytically simpler to leave such parties to the side, describing them, as Mason J. did, as something else. Nevertheless, such persons do style themselves and consider themselves agents by name, and do act as skilled representatives on any common measure of the term. They are so common that each year, when I ask my students to give me an example of an agent, the person raising their hand invariably refers to an estate agent. And I'll leave to the side the one character in my class a few years ago who cried out, "Secret Agent James Bond, 007. Different type of agent, quite obviously. Anyway, to return to more prosaic estate agents. Of course, it is true that vernacular labeling is not necessarily determinative of whether a legal concept applies to them. Nevertheless, the general desirability of reconciling theory and practice does require a consideration at least of how to classify such intermediaries. We can't just call them something else. What is notable is that while such a person does not have the external powers to conclude contracts and bind the principle associated with agency in its paradigm form, in almost every respect, the other features of agency apply to them. There is a manifestation of an authority to act, and it is commonly encapsulated in a secondary contract of some kind, often called a mandate, although strictly speaking it is not, but a form of independent service contract. The person acts as in a form of representative capacity with third parties. These persons are appointed because they have particular skills and abilities, and they are able to assist the principal with something that the principal has neither the expertise to carry out nor the time or energy to devote to it. The person will normally be entitled to a commission for the assistance, if it is earned. Ironically, a significant number of the authorities on agents' commission in the law reports and books on agency tend to involve such intermediary parties, although many of these books exclude them as agents. And most importantly, the nature of the internal relationship between the parties is fiduciary in the same sense as in paradigm forms of agency. Once again, many of the case authorities relating to the fiduciary obligations of an agent are drawn from factual situations involving estate or insurance agents. Taking the above into account, it seems essential then to include such parties in a taxonomic discussion of agency. Therefore, in addition to the paradigm case of agency, I therefore recommend it is time for South African law to recognize the following: that a fiduciary relationship of agency may also emerge in a wider sense, where the agent is authorized to assist the principal as a representative, but the agent has no power to affect the principal's relationship contractually with third parties. They may not be agents of the paradigm form, but the equivalence of their internal relationship and their representative interaction with third parties means that they should be recognized as a qualified species of agent for the purposes of a full and dimensioned discussion of agency. Such agents may be referred to, seventh point, as unempowered agents. While this broader approach to agency has definitely not been de rigueur amongst South African authorities, Alistair Kerr was one who argued for it for many decades. He was considered at the time a complete maverick for suggesting so, if that word is suitable, bearing in mind one could not imagine a person less like Tom Cruise's maverick character in one of his other acting guises. But it is fascinating to see that the main Anglo-American authorities I have mentioned tonight have come round to this view, now unambiguously recognizing a species of unempowered agency to allow us to explain agency in a complete sense. So in conclusion, the aim of this lecture, which is based on a chapter in the displayed book published in 2021, has been to propose a more coherent and complete conceptual explanation of the law of agency in South Africa. While some of the features described above appear in our judgments and the main literature, disputes about the nature and reach of agency have long existed, reflecting a failure to see agency as a multifaceted synthesis of numerous characteristics. My approach in this lecture has therefore been elemental and synoptic, that agency is neither merely a contract nor merely a power exercising act. Rather, it is a complex fiduciary relationship involving a principal's manifestation of authority in one of numerous different possible ways that an agent acts in a representative capacity. Once authority can be identified, in paradigm cases, the agent will exercise a power to perform juristic acts for the principal. But additionally, agency law should also recognize, as conventional society does, that the many agents who act in a representative capacity with all the internal features of agency, but who are in truth unempowered. Naturally, this all masks many issues of detail. But in the doctrinal tradition which my research represents, I submit that proposing solutions to finer issues can be achieved more successfully if there is clarity, at least, about agency's fundamentals. Thank you.
The entire law of agency. And now you can see why one can say without any doubt that he is one of the leading scholars in the field. And we are lucky to have him in our faculty. I'm sure our students appreciate, this is the reason why our students appreciate him and they love contract law. Since I'm an agent of the university and my responsibility is now to say thank you, Professor Glover, for such an illuminating lecture and to present you with a little token of appreciation.